Hearings, trial, let's talk all things court. Hello, foster care and adoption friends. My name is Lauren, and this channel is called Lauren Fosters, where we talk all about foster care and adoption. And today we're going to spend time talking about court. Who are the key players in court? What's the difference between a hearing and a trial? And what can I expect when I come to court? Should I even go to court in the first place? What kind of things are talked about at court? We're going to get into all of it. First things first, it should come as no surprise to you that a huge piece of the foster care puzzle is the court systems. From the time you take a placement to the time everything is finalized and said and done, you're going to have hearings that happen throughout the life of the case. Now, whether those hearings are spaced out every 3 months, every 6 months, might depend on your area. And you also may hear some different terminology when they're referring to those hearings, maybe a placement review, a permanency hearing, or they may just flat out call it a hearing. And I want to point out that a hearing is something that's going to happen regardless of whether monumental decisions are being made or not, because usually they're using hearings to make sure that the judge and all parties involved are reporting on how everything is going with the case. I definitely want to talk about some of the key players involved when you go to court, but before I do, I want to explain something that may happen, as well as all those planned out, timed out hearings that you're going to have throughout the life of the case. You may also have planning meetings that happen before you go to your hearing. So don't be surprised if you have something called a family planning meeting, or your area could call it like 100 different things, but something where a lot of the same people you're going to see in court would either sit around a table or call in, or even do something virtually where everybody was talking ahead of the court date, so that everybody was on the same page when it was time to show up to court. And a lot of times in those meetings, you'll hear from bio mom, bio dad, or whoever the children were removed from. You may even have a voice at those meetings. I have been in places where you just have your hearings, nothing is said in between other than your regular caseworker visit. But I have also been in areas where you have the meeting, the hearing, the meeting, the hearing, and so on. Whether you decide to go to the hearings or not is totally up to you, and we'll get into that in just a minute. But I would say for sure, and it might even be mandatory in your area, definitely go to those planning meetings. Some of the key players when you go to court: you're going to have the judge, you're going to have the ad litem, which kind of acts as, from a legal standpoint on behalf of the children and their best interests. You're going to see whoever the children were removed from, most likely, are going to be asked to come to court, and they're going to have their own legal representation. And a lot of times, let's say you've got mom and dad, each one of them are going to have their own individual lawyer. Of course, your child's caseworker is probably going to be there, and potentially they may have their own lawyer. So CPS may send their own lawyer as a representative. Potentially the CASA worker may go to court, although I will say in our area, the CASA worker, so the court-appointed special advocate, doesn't come to court in our area. They send in a report every single time. So it may kind of vary on your particular local area's CASA as to whether the actual representative comes or if they send in a report instead. And then out of the 3 states we have fostered in, just this one, we've seen something called the Juvenile Officer. I know at least 2 out of the 3 states we've been in haven't had a Juvenile Officer. So that may just be up to your particular area. And honestly, there may be players in that whole courtroom situation that I haven't even mentioned. And of course, then there's you, if you decide to show up, although we really, as foster parents, take a back seat at court. Everyone I've mentioned so far may actually have some sort of verbal say in the whole conversation. But you don't, as a foster parent, actually have a seat at the table, if that makes sense. You're not a party to the case, and I'll get into that in just a bit as well. I do want to mention, though, that it wouldn't be that strange to show up to court and be called in because the case is being called. Go in and sit down and then look around and realize you don't recognize anybody there. So you don't recognize the caseworker is not there, or it seems as though the caseworker's not there, or maybe you don't recognize the CASA worker, but you thought potentially CASA was going to be there that day. And the reason I bring that up is because sometimes some of these organizations will send representatives, they'll send the supervisors instead. So in our area, for example, sometimes the supervisor will come and just sit into all the cases for that particular day, regardless of the caseworker that's assigned to that particular case. So if you walk in and you don't see familiar faces, it doesn't necessarily mean that the parties involved haven't shown up. It just may mean that there's supervisors there instead. So hearings are going to happen regardless of whether you go. Hearings are going to happen regardless of whether there's something big or major going on, whether in their placement or with their biological parents or whoever they were removed from. Hearings are going to happen over the life of the case either way. But then there's something called trial. And here's where I want you to differentiate a bit. The hearings are going to be a check-in, whereas the trial is something that happens at the very, very end of the lifespan of these cases, and usually it's only done in order to terminate parental rights. Trial would be the point where they've tried everything under the sun, parents have not wanted to relinquish rights, but yet they cannot reunify, and now they're looking at terminating parental rights. So you'll also hear it called a TPR trial, terminating parental rights. And because most people don't understand the terminology and what exactly we're doing at those hearings, you'll see a lot of people get really confused, and you might go to a hearing as a foster parent and have a friend right afterwards, and this has happened to me quite a bit, say, so did they terminate parental rights? So are you adopting tomorrow? You know, did you adopt them then? But generally speaking, once again, these hearings are just a check-in on all parties involved. So let's talk about that just a bit further. When they're checking in during a hearing, they're usually checking on two main parties: the biological parents, or whoever the children were removed from, and the children themselves. So the hearing isn't for you as a foster parent per se. As far as the parents are concerned in court, they're trying to check in to make sure that parents are following their service plans, that they're doing all the things that they have been asked to do in order to be reunified with their children. As far as checking in with the kids, they're usually asking, how is school going? How is therapy going? How is the placement going? I think when it comes to court, there's two questions on a lot of foster parents' minds. One, should I go to court? And two, if I go to court, am I going to be questioned when I get there? As far as whether or not you should go to court, that answer really is up to you as an individual. I personally always recommend going to court. I think caseworkers do a great job of trying to explain kind of after the fact maybe everything that happened there, but I feel like I've always gotten much more information showing up. You kind of hear everybody talking and you see everything kind of play out in front of you, so you don't miss a thing. So my own personal preference is to go whenever I can. So then begs the question, are you going to take the stand and are you going to be questioned at a hearing? And the answer truly is, I don't know. Generally speaking, probably not. It's not that common, especially if the case is still very young, to have a foster parent take the stand or speak up. The judge may have you just from your seat. They may ask how the child is doing, and you just kind of keep your answer short and sweet. They're asking specifically, how is that child doing in your house? And they're asking specific things that have to do with your experience with that child. What the judge is not asking you is, have you heard anything about the biological parents, the grapevine? Has caseworkers said anything? They don't want to hear hearsay. They want to know facts. And the facts they want to hear from you specifically are directly related to your children. A big reason for these hearings is checking in on permanency goals. You may find in your area that you have one permanency goal that kind of changes throughout the life of the course. You may even have two. In our particular area right now, we have two going at all times. In our last state, we had one going at all times. So generally speaking, when the case is young, the permanency goal is going to be reunification, regardless of the details of the case. And this may make you scoff as a foster parent if you hear case details that seem really extreme, but every parent has the absolute right to work hard and reunify with their children when it's possible and when it's safe. We're not the judge, we're not the jury, and we have to allow the court system to do its job. I think when you're not in the foster care world, there's definitely some misconceptions about hearings, because we assume that like these big mountain decisions are being made, that we're gonna show up and then all of a sudden they're gonna be like, let's adopt today. And like never, that does not happen. At least I've never heard of that happening, something major like that. Even terminating parental rights is gonna be in that trial phase at the end of the life of a case, after they've tried every other method to make things work for reunification. But those big monumental decisions are generally happening in the hearing. So let's go back to those permanency goals, talk about those permanency goals that could change throughout, because that is something that could change during a hearing. Once again, the main permanency goal, the first permanency goal, is always going to be reunification, but you may find as the case goes on, if parents aren't working their service plans, if it just doesn't look like reunification is even a possibility, they may start changing permanency goals to things like guardianship or things like adoption. And once again, in our area, they tend to have two going at all times. And so when we first got our placement here, their first permanency goal was reunification with a secondary goal of guardianship. And that was just to say, basically, we hope to reunify, but if we can't, we'll do this other thing. And then later it kind of switched a little bit. It was reunification, and then with a secondary goal of adoption. If that's not gonna work out, our secondary goal is adoption. They've been with this family for quite a while, so we're hoping that adoption works out. Then down the line a bit further, and right before trial, when they feel like they had really done everything they could to work with the biological parents for these kids, it turned into primary goal. First goal was adoption. Secondary goal, was reunification. Reunification never went away, even up until trial. So don't let reunification goals throw you off. That would be one of the biggest things that tend to happen during hearings. Otherwise, they really are just checking in on the parties involved. I mentioned before becoming a party to the case as a foster parent. So as a foster parent, just existing, we are not a party to the case. Therefore, we're not, generally speaking, when we sit in court, we're gonna sit on the chairs or the pews or whatever they have there, but we're not gonna be up at the table with the caseworkers and the lawyers and the biological parents, because we're not a party to the case, which basically means we have no legal representation and we don't really have much of a voice in court unless the judge asks us a quick question in court. Generally speaking, we're not going to take the stand. The only times I've seen foster parents become a party to the case is when they feel like something in the case is going terribly awry. I don't think it happens very often. I really want to believe that caseworkers and judges and ad litems are doing their job, but there are times when foster parents really want their own legal representation, and let's talk about what that does for them a little bit. So what legal representation does for the foster parent, it allows their own lawyer to call their own witnesses separate from everybody else's, and it also allows them to cross-examine. But chances are the witnesses your lawyer would call forward are the same witnesses that the caseworker's lawyer would call forward anyway. So there's not much of a need for you to have your own lawyer to try to become a party to the case unless you feel like that kind of thing's not already happening. The people I've seen called forward in hearings, if they were going to call someone forward in hearings, you usually see it more in trial than you're going to see during a hearing, but I have seen it in a hearing, is the child's teacher, child's therapist, maybe the child's youth pastor, anybody that really can speak into why one party or the other thinks it's a good idea or a bad idea to reunify the child. So then there's the question, should I even go to hearings? For the most part, you won't be expected to go to hearings. I do think it's a good idea to go to hearings. You kind of get to see the faces you won't get to see very often. You may never meet the ad litem outside of court. Only once ever, in one case ever, have we met the ad litem outside of court. Otherwise, we'd never be able to know who she was. And as I mentioned before, even though it's not super common for you as the foster parent to be asked questions during hearings, it does happen. So it's good to go if you can, just in case the judge does have questions. I also think there's something really important about just showing up. I think it says a lot to the caseworker and the judge. I think it also says a lot to your kids if your kids are old enough to understand what's going on. You definitely want to be a voice for them if you get that opportunity. I know this isn't the most popular opinion, but I've enjoyed getting to know some of the biological parents during hearings and in the waiting rooms as we're waiting for hearings to start. I think you have to be very careful there. I would ask you to tread very lightly, using those as times to get to know parents. If you have not met them yet, that's probably not the time to walk up and do more. Maybe just a simple introduction. Hi, my name is Lauren. I'm so-and-so's foster parent. I just wanted to introduce myself, and then kind of let that be the end of the conversation. I would just be really careful. I've had caseworkers caution us in the past, be careful what information you share. If questions start getting asked, you could always refer the parents to the caseworker if it's a question you don't feel comfortable asking, or if you just don't know the answer to something. It's just best to have them go through the proper channels. But in most cases, you'll have met the biological parents because visits will have been going on, and so you will have been able to see them outside of court. So just a simple hello, how's everything going in court? I've always thought it was great. I've never avoided parents in court. I've always tried to kind of say hi and check in on them on a very light sort of way, if that makes sense, not making that like a super deep moment or anything. But I do think that biological family relationships are important. I talk about that in other videos. So when it's safe and when it's possible, I do chat with biological parents. So obviously that means that bio parents are invited to court every single time. They do have a seat at the table. They are parties to the case. So you should plan on seeing them there if you do decide to go to the hearings. I will say the one time I would highly suggest not going to hearings is if there's a genuine safety concern. And I think if you're a new foster parent, you might think like everything's a safety concern. But we've only one time ever been told to be very careful coming to court, because it'd be the one time we ran into a particular parent that we were told was very, very hugely dangerous. And I will say, now that the case has gone on, I don't feel threatened going to court and seeing that person there or anything like that. So I'm glad that I've made the choice to go. But I will say that if you're ever worried about your actual actual safety, make sure that you have some sort of plan for either the caseworker to kind of meet up with you, or they may even have you check in with the bailiff or sit in a certain area so you're not interacting with that particular person. If it's not safe to go to hearings, or maybe you just prefer not to go to hearings, maybe you have a full-time job, you're working and just you can't go every single time, you can send in a court report that is read by the judge. Usually that's sent into the county clerk, but you can ask your caseworker if there's another route they'd like you to take. Sometimes it's a worksheet they'll have you fill out, and sometimes they'll just have you write up or type up a letter and send that in. If you have children that are old enough, they may even allow you to send in letters from the children, but it's definitely not something you would do from day one. I would wait till the case has gone on for a while and then chat with caseworker to see if something like that would be a good idea. This video is part 1 of 3 for this series, so even though we've kind of stopped this conversation on hearings and we haven't really gotten into trials and what happens if, you know, the permanency goals now change and we're kind of going towards trial, so keep an eye out for video 2 where we will discuss all of that. But anyway, I hope this was helpful. If you have any questions, I'd love if you comment below. If you've been down this road and you have experience, feel free to answer some of those questions below. Like, subscribe, and I will see you next time. All right, bye.